next further?
No, Your Honor, we're gonna be in courtroom too.
Oh, okay.
You also position number 3.
All right, I'll hold on a second. Let me do my opening remarks and then we'll get started. All right, there you go. I didn't see on the screen at first. All right, we're ready to start. All right, ladies and gentlemen, good afternoon. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after the arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against you. The cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we're going to address several matters, if they're appropriate for today, which include bond, possible arraignment, or consideration of a possible plea offer if one is made at this juncture by the state. I also want to let you know that we will be resetting some of the cases for a future SAP calendar. And Katrina, my date is January
27th.
January 27th is the SAP reset date. Also, I want to advise everyone that this entire proceeding is being recorded and live streamed on YouTube. I want you to know that you do have certain constitutional rights. And I want to remind you that you do have the right to remain silent, that anything that you state about the facts or occurrences of your case can and will be used against you. So you need to govern yourself accordingly, listen to your attorney, and do as they tell you when they ask you to not make statements that may affect your case. Also, you do have a right to an attorney, so you will see your attorney on the screen. If you've hired a private attorney, they will come in as well, and you will see them and be able to have their representation during this calendar. All right, if we're ready to begin, we're starting out courtroom 2. You said position 3.
That is correct, Your Honor.
All right. All right, are you Mr. Brandon Dean?
Yes, Your Honor.
Keep your mask on.
Okay, this is case number 22 CR 000-168C. You're being charged with 1 count of obstruction of a law enforcement officer, giving a false name, address, or birth date to law enforcement officer, and a 2nd count of obstruction, all on the offense date of January the 11th, 2022. Pre-trial, do we have anything today?
Second arrest. He was arrested in 2018 in DC for threats to do bodily harm, 2 counts. It says null diversion, so I guess it was null pros. He's wanted out of Clayton County for vehicle theft.
Yeah, that's an open warrant.
Yes.
Okay. All right, thank you, Mr. Toussaint. The next, oh, I'm sorry, Miss Arnold. I was looking for my ASG. Happy New Year to you. I don't think I've seen you this year yet.
Yes, Happy New Year, Your Honor.
Good. You may go ahead and proceed, Miss Arnold.
Thank you. So, Your Honor, here in this case, the incident happened on January 11th, 2022 at the location of 1123 Peachtree Street in Atlanta. Officers were called, officers received a call, and when they arrived, they determined that this was to be a civil matter between the defendant and a Mr. Toth, T-O-T-H. The defendant did not like the outcome of the investigation and requested that a supervisor be called. A supervisor did arrive and informed the responding officers to complete an incident report. When Officer Torres asked the defendant for his identification, he stated he did not have a state ID. However, he provided his name, with that name being Mr. Braden Dean, Bradun Dean. When Officer Torres entered the defendant's name that he provided, it came back as an alias for Brandon Dean. When Officer Torres asked the defendant to verify the name again and provide the last four of his social security, the defendant once again gave the name Braden Dean, as he had before. Mr. Toth, the other person that was on the scene at that time, then provided officers with the name of Brandon Dean, who is the defendant here in this case today. And Officer Torres was able to locate the defendant's information, and they saw that he had an active warrant from Clayton County for vehicle theft. Officer Torres went to place the defendant in custody, and at that point, he ran away from the location. After canvassing the area, Officer Torres and Officer Schaefer located the defendant and attempted to place him in custody. However, he actively resisted by using his strength to prevent officers from placing handcuffs on him. Both officers received minor lacerations and swelling to their hands as a result, and the defendant was then able to escape under a fence. However, other officers were finally able to gain control of him and place him in custody. For these reasons, Your Honor, we are requesting that there be a $1,000 surety bond set for count 1 for obstruction of the law enforcement officer. We're asking for a $1,000 surety bond for count 2 for obstruction of a law enforcement officer, and a $500 surety bond for count 3 for giving false name, address, or birth date, for a total of a $2,500 surety bond. We're asking that there be no further contact with Officer Torres or Officer Schaefer, and that the defendant have no drugs, alcohol, or weapons on his person.
Okay, at this address, the 1123 Peachtree Street, is that a residence or a business, or do we know?
I can look it up really quick, Your Honor, but I did not see that mentioned in the warrant, what it was specifically. I don't know if Ms. Gant knows exactly.
Are you aware, Ms. Gant, or does the police report state that?
Your Honor, I am not representing this client. It is PD Daryl Coleman. However, she is having technical difficulties. She's logged in, but she's unable to get her camera to work. And she also can't work the phone. So she's trying to resolve that situation now.
Oh, okay. Daryl Coleman, Mr. Coleman?
I see
She-
Mr. Coleman on. Is it Mr. Coleman? He's saying she. Is it Mr. Coleman?
Daryl Coleman.
Okay.
She's
Yeah.
on, but of course having technical problems. So she could
Daryl
not
Coleman
hear.
is a he.
He.
Yes,
Yes.
Daryl is a he. So are you talking about Ms. Thomas or Mr. Coleman?
Mr. Coleman.
Oh, okay.
Okay.
I see that he signed on. He just may have to sign out and come back in. Ms. Lewis, do you want to?
Yeah, I just talked to him in the chat and let him know that I could see him on the screen, but I cannot. He need to start his video or his,
Oh, I see. Okay,
he's there, but I don't know what's going on.
gotcha.
Okay, it seems like he's unmuted now, just unmuted.
Okay, let's see if we have any progress.
He probably need, Daryl, if you can hear me, please sign back off and log back on.
Right. Sometime that helps.
We do have a private attorney on for position number 5. if you
Okay,
want to go with that.
I think I see that in the chat now. I hadn't checked in my chat.
And I'm just waiting for Mr. Coleman to log back off. I can admit him in.
Okay,
And Your Honor, they may be able to clarify again the defense, but I'm looking it up and it looks like when I pull it up here on the maps, it's just It's not a specific location. It's just on the street of Peachtree Street.
Okay. Because I was wondering about that, just to make sure.
Judge, do you want to go forward with the private attorney, or we can move on till he gets on, because he hasn't logged on yet at this point?
Okay, I hate to break up the monotony of a case that way, but I have taken notes.
Hold on, let me see. He's on now. Let me
Wait a
see.
minute, he may be
Comes
coming.
on. Yeah. I don't know if he's at a computer with a camera or not, because he just logged in and we still don't see him.
Right, and he's logging in. I don't know if he's downtown or not. You know, some of those county ones don't have cameras.
Mr. Coleman, can you hear us? Something is wrong.
Okay. Deputy, I apologize, but you have to play little musical chairs there. Can you remove Mr. Dean or put him in the back for a second? And then possibly bring up David Fernandez? Is that possible, position number 5?
Yes, Fernandez is on the way.
Okay, thank you. And there you go. Is it Mr. Majeski? Am I pronouncing that correct?
It is, Judge. I haven't seen you in a while. It's good to see you.
You too. You too. Thank you.
Sorry about the weird view here. I couldn't get the camera on my laptop to work, so I'm using my iPad. There must be something going around with this tech right now.
Yeah, maybe so, because if my other PD is having issues too, and that does happen. But I will call this case 22 CR 0000169F. At the screen, are you Mr. David Fernandez?
Yes, Your Honor.
All right. You are being charged with 1 count of willful obstruction of a law enforcement officer. The offense date is January the 4th, 2022. Do you see your attorney on the screen there, Mr. Majeski? He's waving at you. Okay, good. All right. We will go ahead. Pre-trial, do you have anything?
First arrest. SOB jail was the recommendation.
Okay. All right, Ms. Arnold, go ahead.
Actually, Your Honor, if I may, we
Yes.
would actually like to request a breakout on this with Mr. Majeski, yourself, and Mrs. Arnold.
Okay. All right, Ms. Lewis. She'll do that for us in a second.
Who would like to be included in the breakout room?
Ms. Arnold, Ms. Falk, Mr. Majeski, anyone else? I think it's just us.
That's all for myself, Your Honor.
Okay,
Okay, give me a second. There we go.
okay. I need to do better today reading my chat.
Oh, actually, I did not have an opportunity to put it in a chat. But I just received some information that we just.
No, Ms.
requires a
Arnold
breakout.
did. Ms. Arnold put in there. She said we
Okay,
need to break
wonderful.
out. I just didn't pay her any attention. I apologize.
Works out fine for me, Judge. I got some stuff. I got some information on this case as well that I'd rather share in that form.
Right, great. We will.
Can everyone see and hear me now?
Yeah, they're in a breakout right now.
Okay,
Okay, we see you now, Daryl. I don't know what was happening.
I don't either.
But when they come back, they'll be on position number 3 after they get done with number 5.
Yeah, I guess that's where you all were doing position 3,
Yeah, but they're
first one, because
position 5 right now. So,
all right,
okay, well, I'm glad we got you.
yeah. Are you all down in G33?
No, we're not down at G33, but she's remote from home. Do you need to go down there?
No, I'm here at the courthouse.
That's what I'm saying. Do you need to go down there too?
But it seems to be working now.
Last Wednesday, I could not see him because of
All right, Ms. Lewis, are we all back?
It looks like it.
Okay,
Yeah, everybody's out of the break room.
okay, great. All right, Mr. Fernandez, you still with me?
I'm here. Can you hear me now?
Oh, hello, Mr. Coleman. Happy New Year to you.
All right. Happy New Year to you too.
What have you
One
done to your
second.
equipment over there? We're messing with you.
I'm a defender.
Can you hear us?
That's my client from the jail. I can't
Which case are we on?
Mr. Coleman, we're finishing up with position 5 and then we'll pick back up with you.
Okay.
Okay, all right. So you can mute yourself for a moment. All right, thank you. All right, Mr. Fernandez, we've discussed your case and I am going to grant you a $1,000 signature bond through the jail. And when you're released, your conditions are to comply with what you've been doing and comply with your treatment. And so we want to just make sure that you continue with that. Okay? And so, Ms. Lewis, he's going to be placed on which calendar? Is he going back to the division?
He's going back to the original division, Judge.
And I'm sorry, Mr. Majeski, I do not have a court date for you, but
They're going to Judge Richardson to further notice.
okay. So it will be Richardson further notice. All right, but there's a $1,000 signature bond through the jail. And remember, no drugs, alcohol, or weapons while on bond, except for any prescriptions that are prescribed medically. All right?
Okay.
All right, Judge, can I just ask a quick question? That means he just has to sign himself out, basically?
Correct.
Okay. And also, if you wouldn't mind, Judge, I see my friend, Miss Lewis, on the call. I haven't seen her in a while. Just let's say Happy New Year to her.
Happy New Year. Don't forget to file that entry appearance, sir.
Yeah, I'll get it done later this week. Thank you.
Get you. Okay.
All right.
Thank you.
That's
Appreciate
it
it.
from, okay, can I be excused, Judge?
Yes, you may be released. Thank you.
All right.
All right. All right, and we're back to position number 3. Mr. Dean.
Yes, Your Honor.
All right, Mr. Coleman.
I'm ready.
Daryl, did you hear the history?
I did not. Again, I was trying to fix my camera.
Hold on. This is second arrest. Last was 2018, threats to do bodily harm, 2 counts out of DC. I think it was NAR Pros, because it says NAR diversion. And he has a vehicle theft warrant out of Clayton County now.
All right. Do you want the state to go again, Mr. Coleman?
Yes, Your Honor. Thank you.
Okay. All right, Ms. Arnold.
Okay, so Your Honor, this incident happened on January 11th, 2022 at the location of 1123 Peachtree Street in Atlanta. Officers were called and when they arrived, they determined the matter to be a civil matter between the defendant and a Mr. Toth, spelled T-O-T-H. The defendant here did not like the outcome of the investigation and requested that a supervisor be called. A supervisor did arrive and informed the responding officers to complete an incident report. When Officer Torres asked the defendant about his identification, he stated that he did not have a state ID. However, he provided the name of a Mr. Braden Dean, Braden spelled B-R-A-D-U-N. When Officer Torres entered the defendant's name, it came back as an alias for Brandon Dean, who is the defendant in this case. Officer Torres then asked the defendant to verify once more the name provided and to give the last 4 of his social security. And again, the defendant verified with the name of Braden Dean. The other individual at the incident, Mr. Toth, provided officers with the correct name, Brandon Dean. And Officer Torres was able to locate the defendant's information that way and saw that he had an active warrant from Clayton County for vehicle theft. Officer Torres went to place the defendant in custody when the defendant ran away from the location. After canvassing the area, Officer Torres and Officer Schaefer located the defendant and attempted again to place him in custody. However, he actively resisted, using his body strength to prevent officers from putting him in handcuffs. Both officers received minor lacerations and swelling to their hands as a result. The defendant was able to escape once more under a fence, but other officers were able to gain control and place him in custody. Your Honor, based on the facts of this case, we are requesting a $1,000 surety bond for count 1 of obstruction of a law enforcement officer, a $1,000 surety bond for count 2 for obstruction of a law enforcement officer, and a $500 surety bond for count 3 for giving false name, address, or birth date, for a total of a $2,500 surety bond. We're asking that there be no further contact with Officer Torres or Officer Schaefer. Torres spelled Torres, Schaefer spelled Schafer, and that the defendant have no drugs, alcohol, or weapons.
All right, Mr. Coleman.
Your Honor, I will be requesting a signature bond from Mr. Dean. He is 29 years of age, resident of Atlanta, Fulton County. This is only his second arrest. He states to me that he is a graduate of Howard University. He's currently employed his own company, Campaign X Policy. Again, given the very brief criminal history that he has, I'd be requesting a signature bond.
And what did you state again as far as employment? I heard grad of Howard
Campaign,
University.
he has his own company, Campaign X Policy.
Own company, okay. All right, I'm going to grant the $2,500 surety bond, which will be $1,000 on each of the obstruction charges and $500 on the false name. Also, I'm going to order no further contact with Officer Torres and Officer Schaefer, as well as Mr. Toth, T-O-T-H. No drugs, alcohol, or weapons while on bond. And this case will be reset to January the 27th if the party does not make a bond prior to that date. Is there anything else I need to take up?
No, thank you, Your Honor.
All right. Thank you. All right.
Nothing further from the state, Your Honor.
Okay, thank you. That will conclude this matter. I think, Mr. Coleman, you may need to call your client later. He has his hand raised. I'm not sure what his question might be.
May I please ask?
If I may ask now, so what, did you have a question?
Yes, Your Honor. Respectfully, I just wanted to acknowledge that this was my residence, and the address that was put in the record is not the correct address. But I was simply.
Sir, I wouldn't advise you to speak about the facts of the case at this time.
But I've not ordered a stay away or anything from that location or any similar location. So if you make bond, you can go back to your residence. I was asking, the 1123 Peachtree is not your residence?
No, Your Honor. No, Your Honor, it's not.
Okay,
Your
you
Honor.
can speak to your attorney about that later, but it is not relevant at the moment to my ruling. I just asked that question earlier.
My anxiety is about the surety bond because I do want to express that although I own a company and have a college experience, I am impoverished and have been for a very long time. And
I did inform the judge of that, sir.
I am indigent and I have been displaced before. And if I am not able to be released to deal with this matter, which is mostly civil with Clayton, I'm going to experience more hardship. If I had $250, I would absolutely pay it so that I could leave, but I don't know if I will have it, Your Honor. And I would certainly not like that to make me homeless or lose everything that I have or not be able to adjudicate this issue in Clayton County. I take responsibility for my actions, but I don't want it to be understated that I am experiencing serious hardship, and this would reset or offset my entire life that I tried to rebuild. with this policy group, with buying a vehicle, with starting a company, with staying in Atlanta. I'm not a student of the law, but I'm an apprentice of the law. I understand my failure. I thought I was protecting myself and standing up for.
Okay, again, so I'm gonna ask you not to speak of the facts of the case at this time.
Yes, sir.
All right, only thing that I can do is, as far as the bond goes, I'm going to leave it as a surety bond, Mr. Dean, and I can lower it on one of the obstruction charges, make that 500 so that it will be a $2,000 surety bond. And so, Ms. Lewis, if you can note that.
I'll note the third one because the third one was an added charge. He was only arrested for 2 charges. The other obstruction was an added charge. For
Oh, okay, okay. So that'll be a $2,000 surety bond, and if you don't make bond, your case will be reset for January the 27th. All right?
Your Honor, I'm responsible for that full $2,000.
No, if you go through a bonding company, it'll be just over 200, sir.
Thank you, Your Honor.
All right, you're welcome. Thank you.
Deposition 2.
Okay. All right, are you Mr., is it Ariania Davis Gray?
Yes.
Ariana Davis Gray.
And I'm sorry, ma'am. Okay. And so this case is 22 CR 0001638. You're charged with 1 count of DUI, less safe, 1 count of failure to obey signs or controlled devices, and then a 3rd count of expired or no license on person, all with the offense date of January the 11th, 2022. Do you have anything pretrial?
Third arrest, 2016 FTA, not prosecuted. 2016 driving without a valid license, out of Marietta. That's it.
Okay.
That was
Okay.
SOB jail recommendation, if given the signature bond.
Okay.
All right.
Thank you. Ms. Arnold?
Yes, Your Honor. The state is requesting a $3,000 surety bond for count 1 on the DUI, drugs less safe, a $500 surety bond for count 2 for failure to obey a sign or control devices, and a $300 surety bond for count 3 for expired or no license on her person, for a total of a $4,000 surety bond. We are also requesting that there be no driving and no drugs, alcohol, or weapons. Your Honor, this incident happened on January 11th, 2022 at the location of Old Alabama Road and Nesbitt Ferry Road in Johns Creek. Officers initiated a traffic stop on the defendant after observing her vehicle enter the intersection of Old Alabama Road at Nesbitt Ferry Road against a red light and then proceeded to make a left turn. Officers, when they initiated the stop, could smell the odor of marijuana coming from the vehicle and asked the defendant to exit the car. And when she exited the car, the odor became much stronger. Officers then explained the reason for the stop to the defendant and asked, and while they were speaking with her, noticed that her eyes were bloodshot. When asked when she last smoked, she stated that it was earlier in the day. Officers then asked if she would agree to participating in a roadside sobriety evaluation, and the defendant agreed. When officers searched the vehicle, they found 2 burned marijuana cigarettes and made note that smoke blew out of the car when the defendant opened the car door. At this point, after they conducted the evaluation and the defendant, I'm sorry, Your Honor, after they conducted the evaluation and found the cigarettes in the car, at that point, the officers placed the defendant under arrest. A check of the GCIC showed that the defendant did have an expired Georgia license from August 10th, 2020. Your Honor, we are requesting the bond as stated due to the fact that we do believe the defendant is a danger to the community. If she had not been stopped by officers, things could have been much worse and other people could have been injured on the roadway due to her driving while under the influence. So we are requesting for that reason, the $4,000 surety with the conditions as stated.
All right, your recommendation, did you say 3,000 on the DUI, 500 on the second charge, and 300, which would be 3,800? Or did I
Yeah.
miss something?
Yes, Your Honor, I said $500 for count 3. So 3,000 for count 1 and 500 for each additional count.
All right, I have your recommendation. Mr. Coleman, is this your case as well?
It is, Your Honor. I'd be requesting a signature bond from Miss Davis Gray. Only third arrest. The last arrest was back in 2016, some 6 years ago. She's 22 years of age. She does have her associate's degree. Currently employed at Benihana. Has little to no money to post a bond. Again, I remind the court at this time that these are just allegations. We will be requesting signature bond.
So there was no accident, is that correct?
No, it does not appear that this was an accident.
All right, I'm going to grant the signature bond through the jail of $3,000. With that being $1,000 on the, I'm sorry, $3,000 on the DUI and 500 on the second charge, failure to obey signs and devices, and then 500 on the no license on person. So I'm sorry, it's a total of $4,000 signature bond. I think I said that wrong first. $4,000 total. Signature bond through the jail. And Miss Davis Gray, you are not to have any drugs, alcohol, or weapons while on bond. You are not to drive while on bond, except to go to work, seek medical treatment or the doctors, and to visit your attorney. Those will be the only 3 reasons that you should be behind a wheel. But I guess if you have a license that's already expired, you shouldn't be. You should be taking Uber, public transportation, or getting rides. So actually, let me change that, since your license expired last year, I'm assuming you have not gotten them back. So that would be,
Sorry, Your Honor, sorry. I actually recently just changed it because I also had an invalid address. So I renewed all of that recently, like Monday.
are you stating you renewed your license on Monday?
I was in the process of renewing, yes, ma'am. Mhm.
And your license were reinstated?
I had to finish paying on it. I had to finish paying on it. I paid 2 payments. But I had to pay $35.
That's the reinstatement fee, but there's a reason that your license were expired, and usually it's more than $35.
The reason why it was expired, I didn't use my permit for a long time. I went to Missouri and went to school.
I would advise you to just check with the Department of Driving Services and find out exactly why it's suspended and what you need to do to get it reinstated.
Okay.
Do you just need to put down, no driving unless authorized by DPS? She has to get permitted from.
Right.
I'll put that down on the bond. Because she
Okay.
can't drive unless she got authorization from DDS or some type of permit, because she has a DUI.
Correct. Because otherwise it would be suspended anyway.
That's correct, unless you go to an ASL hearing.
Okay. All right, that will be my ruling. Is there anything else I need to take up, Mr. Coleman or Ms. Arnold?
No, thank you, Your Honor.
All right, no problem. All right, that will conclude this matter.
That's case 14.
All right. Do we have Bobby Simmons?
Yes.
Okay. This is case number 22 CR 0000173G. And you're charged with 1 count of criminal trespass. The offense date is January the 10th, 2022. Do you have anything pre-trial?
It appears to be a first arrest. I mean, it's like 9 aliases on this GCIC, but I think those were, they got to be in error because it's a men name on here too.
Me and
I'm
my,
not really sure.
me and my dad has the same name.
Oh, okay.
Yeah, but it's like a whole bunch of different names on here.
Yeah,
So-
it's something pertaining to my dad, because he has a
I'm-
couple of arrests.
So we'll roll with first arrest based on this. But it was SOB jail recommendation.
All right. All right, Ms. Guidry.
Good evening, Your Honor.
Hi, how are you?
I'm fine. Your Honor, here in this case, on January 10th, 2022, officers arrived at 209 Lakeview Place, East Point. That is the defendant's address. They spoke with Alex Nelson, who stated that he and the defendant got into an argument and he attempted to leave the residence. The defendant proceeded to lock the bedroom door so that he could not retrieve his property. Mr. Nelson stated that he kicked the bathroom door to retrieve his belongings, and the defendant grabbed his phone and threw it on the ground, causing the screen to shatter. Mr. Nelson advised that the phone costed $74. Your Honor, we're recommending a $2,500 signature bond, no further violent contact with Alex Nelson, and no alcohol, drugs, or weapons. The reasoning is because, as pretrial stated, we saw that this is her first arrest as well.
Okay. All right, Ms. Gant.
All right, thank you, Your Honor. We consent to the $2,500 signature bond. We are unopposed to the no further contact order. Ms. Simmons is 41 years old. She was born in Washington, DC. She has been in Atlanta all of her life. She has family here. She has 3 children, a son, 24, and 2 daughters who are 14 years of age. She has a certification in medical coding and billing. And she also has chronic conditions that require medication, which would better be served if she is released. Therefore, I am requesting a signature bond and she denies the allegations. Thank you.
All right. I will grant the $2,500 signature bond through the jail. And there will be no further contact with the victim, Alex Nelson. There will be no drugs, alcohol, or weapons while on bond. And this 209 Lakeview Place, whose address is that?
Me and my son.
That is Ms. Simmons' address.
Yes, Your Honor, that's her address.
Okay, Ms. Simmons, I hope that you can return to that address safely if Mr. Nelson is not there, since you're to have no further contact with him. Whose name is on the lease, or is it a purchase?
The lease is under my son's name. I'm an applicant there. It's me and my son, my oldest son.
So Mr. Nelson should not be there?
He doesn't live with me.
All right, well, I'm going to allow you to go back to that location as long as Mr. Nelson is not there. If he is there, you need to leave that location until he maybe gets his things out to leave, or if he's already left and moved, then that's fine, okay? But you are to have no contact with him.
No contact or no further violent contact, Judge.
I said no further contact.
Okay.
Ms. Gant and Ms. Guidry, since you all agree on the signature bond, is there any agreement or information regarding contact with the victim?
Your Honor, we were unable to speak with the victim, and so that's why we asked for no further violent contact. It doesn't seem as if they've had any other issues, so.
Okay, and thank you, Ms. Lewis. I'll change that to no further violent contact.
And is it SOB through the jail or pretrial? Since they were
Through the jail.
Through the jail.
Mhm. And so this case will be further noticed by the division judge.
That's correct.
All right, if that concludes this matter, we'll close this one out.
Thank you, Your Honor.
Thank you.
All
Your
right,
Honor.
thank you.
All right, then position 8,
Okay.
Grace.
Hi, is your name Willie Grace?
Yes, ma'am.
All right, this is case number 22 CR 000-164J. You're being charged with 1 count of simple battery and a 2nd count of obstruction of a law enforcement officer with the offense dates of January the 11th, 2022. Let's say you pretrial.
55 total.
Okay.
Last arrest was in October for disorderly conduct and terrorist threats. July, simple assault, simple battery, 2 counts. That was out of DeKalb County. February 2021, 2 counts of simple battery. June 2020, simple battery. March 2020, probation violation for obstruction. February 2020, trespass conviction. 2019, criminal damage to property, 2nd degree arrest. 2019, disorderly conduct, public indecency, conviction. 2018, simple assault conviction. You want me to keep going?
Nope, that's fine. Thank you. All right, Ms. Guidry.
Yes, Your Honor. In this case, on January 11, 2022, officers arrived at the location of 1017 North Highland Avenue Northwest. It was just a location at the time. After receiving a call in regard to a fight and the description of the subject was given. Upon looking in the area, officers located the defendant who matched the description. Officers pulled beside the defendant who kept walking. Upon detaining him, the defendant began to pull away and refused to put his hands behind his back. The officer tried to take him to the ground, but she was unsuccessful. She was finally able to get him to the ground with the help of a citizen. Officers then spoke with the victim, Ms. Carol Kelly, common spelling, who stated that she was walking down Virginia Avenue in front of Farmburger when the defendant walked up to her and asked her for 75 cents. When she stated that she didn't have the money, the defendant punched her in the chest. Your Honor, the state's recommending a $5,000 surety bond, $2,500 on each count. No further contact with Carol Kelly. No further contact with the officer, Tynisha, Tynisha Butler. 1-day anger awareness and no alcohol, drugs, or weapons. Your Honor, concerns are that the defendant is a risk of reoffending, given that he had a simple battery from 2021, 2 counts where he was convicted. And in that case, a victim was walking out of a store. He walked up to her randomly and punched her in the shoulder. He ran away back to the store and pushed another individual from behind. He also had another case in 2020 that was dismissed. However, it's similar to this one as well. A victim was sitting in her car and he walked up to the car, pushed the victim's car door against her leg where she just had surgery, which caused her leg to swell. He also has 2 active warrants, one for Decatur and one for DeKalb. He has 2 simple batteries open in DeKalb and a simple assault, criminal trespass open, disorderly conduct, terroristic threats. Your Honor, the list will just go on. So we're concerned the danger of the community and the safety of others. So that's why we're recommending that bond.
All right, this is your case, Mr. Coleman.
Yes, Your Honor. Your Honor, I would be requesting a signature bond from Mr. Grace. Again, I remind the court at this time that these are just allegations. Mr. Grace is 49 years of age, resident of Fulton County. He is a high school graduate. However, he is not working, therefore he has no money to post for bond. It's only 5th arrest, so he does not have much of a criminal history. Again, I would be requesting a signature bond, or in lieu of that, a no bond for Mr. Grace.
Your Honor, just to clarify, he has 55 arrests, not 5 arrests.
I'm sorry, did I mishear?
Yeah, he has 55.
How many do you have, Mr. Trizant, in pretrial? Did you say 5 or 55?
I have no, I said 55.
Oh,
Okay,
I'm
I must
sorry.
have misheard then.
Daryl trying to be funny, Judge.
I thought I heard 5 too, but it's okay. 5-5. We are clear. All right, I am ready to rule if all minds are clear. I am going to order the $5,000 surety bond with $2,500 on each of the charges. I'm going to order a no further contact with the victim, Carol Kelly, and the officer, Ms. Butler. No drugs, alcohol, or weapons while on bond. And I don't think I need to stay away from that address because you said it was just a random. So
Yes, that's
we'll-
correct.
Okay. And I'm not going to order the anger awareness class at this time. I'm going to leave that open for later. And again, this case will be reset to January 27th SAP unless the defendant makes bond prior to that time. All right. Anything else?
No,
Nothing
thank
further,
you,
Your
Your Honor.
Honor.
All right, thank you. That will conclude this case. I think they're muted in courtroom 2. Deputy?
That's all. That's it, right? Just 2 weeks?
Really?
Fuck you, Nick.
Really?
You made me see your dog.
I think I see why they were muted. Good afternoon.
Good afternoon, Your Honor. Position number 1, Ms. Cool.
Okay. All right, are you Megan Cool?
Yes, ma'am.
Your case number is 22 CR 0000162E. You're charged with 1 count of DUI less safe and 1 count of driving improper or erratic lane change, both with the offense date of January the 11th, 2022. Do you have anything pre-trial?
First arrest, SOB jail if given signature bond.
All right, Ms. Arnold?
So the state is requesting a $3,000 surety bond for count 1 for the DUI alcohol less safe and a $500 surety bond for count 2 for driving an improper erratic lane change for a total of a $3,500 surety bond. We're also asking that the conditions be that there be no driving and no drugs, alcohol, or weapons. Your Honor, this incident happened on January 11th, 2022 at the location of Old Alabama Road and Wallonia Trace in Johns Creek. Wallonia spelled Wallonia. Here, an officer saw the defendant driving east on Old Alabama Road. And as she reached the intersection, she did not stay within the eastbound lane and drove almost entirely into the westbound left lane across the intersection. The defendant also drove over the yellow lines for the central lane 2 times before being pulled over. When the officer was at the window of the car, he could smell alcohol coming from the car. And he also saw 2 boxes of High Noon hard seltzer on the passenger floor and one of those boxes was actually opened, Your Honor. When asked if she consumed alcohol prior to driving, the defendant said that she only had a single beer on January 10th, which was the day before. The defendant then agreed to a sobriety evaluation, and upon further investigation, admitted to the officer that she did actually drink 4 High Noon drinks prior to driving. And at that point, she was placed under arrest. The implied consent was read, and the defendant agreed to take the state's breath test and provided samples of a 0.0 grams. And then on the second sample, 0.065 grams. So for these reasons, Your Honor, we are requesting that bond. We do believe, again, that the defendant could be a danger to the community as she was driving on the road and crossing over intersections and not being able to stay within the lane because she was under the influence of alcohol. So for these reasons, so we can keep the road safe, Your Honor, we would like to request again that the bond be the $3,000 surety for the DUI, alcohol less safe, and the $500 for count 2 for driving an improper and erratic lane change, for a total of a $3,500 surety with the conditions as stated.
Okay. Mr. Coleman?
Your Honor, I will be requesting a signature bond from Ms. Cool. Again, I remind the court at this time that these are just allegations against my client. She is 30 years of age, resident of Atlanta, Fulton County. She is a licensed pharmacist. Again, first arrest, we will be requesting a signature bond.
Okay. All right, I'm going to grant the $3,500 signature bond. And I'm going to order this one through the jail. I'm going to order that there be no drugs, alcohol, or weapons while on bond, Ms. Cool. And I'm going to also state to you that you not drive your license are probably, and I'm sure they are suspended anyway with this charge, but you can only drive to work, to seek medical attention, and or to visit your attorney. And so no other driving for pleasure. And these days you can probably have groceries delivered or you can take an Uber to the grocery store, but I only want to know, and once you check with DMV as well, that you can only drive for work, medical reasons, or to visit your attorney's office. So you will have limited driving privileges if that is needed, okay?
Judge, this will be also no driving unless authorized by the DDS. They got to have some kind of permit.
Right, and you would have to get that permit from DDS. All right. All right, good luck to you.
Judge Mincy, I didn't hear the breakdown on that, but I'm assuming it's the same as the subsequent DUI with 3,000 signature on the DUI and then 500 on the less safe.
Yes, thank you.
I mean, the erratic lane change.
I mean, the erratic lanes change, yes. And you have that, Ms. Lewis?
Yes, ma'am, I have it.
Okay. Who do we have in courtroom 2?
Well, position 7.
Breakout room for this one.
Okay, so it'll be Ms. Arnold, Ms. Falk. Is it Mr. Coleman or who's representing?
I believe it's Mr. Coleman.
Okay.
Sorry, it was me. That will be me.
Okay, so we'll be going to breakout.
All 4 of y'all be going to breakout. Okay.
Okay.
Report.
Yeah, yeah, report. Where's Laura?
I know. I'm
They
just
show
saying.
you as an option.
I know, I gotta put you as, I'm in there.
Oh, yeah, okay.
I just changed my name to LM Katrina because I had a state court slash in there.
Right, but you know how we open the rooms?
Uh-huh.
Give me an
Ms.
option.
Katrina, mute your mic, please.
Okay, I'm
Oh,
so sorry.
Let's go away.
All right, Ms. Lewis, we're back.
Okay. Everybody's out the room.
Oh, okay. Mr. Goodman? Courtroom 2, can you unmute, please? All right, and I see a Jennifer on the screen. Are you Miss Jennifer Harden? The victim in this case? Do you wish to address the court? Ms. Harden, do you wish to address the court?
You need to start your video, ma'am.
Can you hear me?
I can. First, I want to know if you want to address the court, because if you do, you'll have to turn on your video. All right, would you like to address the court, Ms. Harden?
Yes, ma'am.
Can you raise your right hand for me? Do you affirm that the testimony that you're about to give will be the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. And can you tell me if you are in fear of Mr. Goodman, or what your position is right now with him?
Right now, I asked for no contact.
Okay. Are you in fear of Mr. Goodman?
Yes.
Okay.
Oh, Lord.
All right. And if there's nothing else, I'm going to go ahead and give my ruling. Do you have any questions for her, Mr. Coleman?
No question.
Okay. You, Ms. Arnold? Say that again, Ms. Arnold. We didn't hear you.
I do apologize. No questions, Your Honor.
Okay. All right. I'll go ahead and give my ruling. I'm going to order in this case, Mr. Goodman, that there be a $5,000 surety bond, and that will be $3,000 regarding the simple assault, $1,000 on the criminal trespass, and $1,000 on the willful obstruction, for a total of $5,000. You are to stay away from the location of 1033 Hollywood Road Northwest. You're to have no further contact with the victim, Jennifer Harden. You are to also have no drugs, alcohol, or weapons once you're out on bond. And also you're to cooperate with an evaluation or assessment from the social worker from the PD's office, and they will be contacting you, okay? So that is my ruling for today. Your case will be reset to January the 27th unless you make bond prior to that time. All right? And that should conclude this case. Deputy? Yes, Ms. Harden, you're free to go. Okay.
Done.
All right, that concludes this matter. It's a $5,000 surety bond.
Thank you.
So, man, can I pay through the bond, or I gotta pay through the jail?
Through the bonding company.
So that was 500?
I don't know what they,
Approximately 500, maybe a little more, sir.
Come on. Come on, man, I'll let you.
So, Mr. Cole, there's nothing you can say, Mr. Cole, about if my job situation. And
I'm gonna call your mother once we're done with court, sir, and let her know what's happening.
We're gonna go to position number 15, Mr. Younes. Come on. Come on. Hey, come on. Let's go down. Come on.
Hello,
All right, are you Mr. Joseph? Is it Eunice?
yes,
Right, this is case number 22 CR 0000175F. You're being charged with one count of theft of services with the offense date of January the 11th, 2022.
okay.
Pre-trial, do we have anything?
8 total. Last arrest was 2020, burglary, 2nd degree.
Ooh,
In February of 2021, they gave him 1 year to serve, which was community time served, and then 1 year probation. So he should still be on probation for that. 2019 shoplifting arrest, 2019 failure to appear, 2019 trespass, 2019 shoplifting conviction, another 2019 shoplifting arrest.
All right. And Ms. Anderson? All right.
Good
How are you?
afternoon, Judge. I'm well, and yourself?
Good. Nice to meet you.
Pleasure. Thank you.
All
Your
right.
Honor, the defendant presented yesterday, January 11th, 2022, to MF Sushi Restaurant in Virginia Highlands. He sat down, ordered several items and food, but when the bill came, he stated he didn't have the money to pay. The restaurant staff called APD, who made the arrest. Your Honor, we are asking for a $1,500 surety bond and a stay away from MF Sushi Restaurant order. MF Sushi Restaurant is located at 299 North Highland Avenue, Northeast in Atlanta. And we're asking for this due to the defendant's pretty significant history of theft, as pretrial indicated, including 2nd-degree burglary, failure to appear, and 3 different shoplifting charges in 2019, indicating a high risk of reoffending, Your Honor. For those reasons, we're asking for the $1,500 surety bond and the stay away order.
Okay. All right. Ms. Gant?
All right, thank you, Your Honor. Mr. Younes disputes the allegations. Today I'm requesting a signature bond on Mr. Younes's behalf, and if Your Honor determines that he is ineligible, then a low bond amount, as he is unemployed and unable to make bond at this time. I have been in contact with his mother and brother, who are unable to offer or contribute anything at this time. Mr. Younes is 24 years old. He was born in New Jersey, but he has been in the Atlanta area for the past 3 years. He has family in this area. He completed high school and some college in the area of general studies for about 1 semester. Your Honor, I misspoke. He states that he just obtained employment at Raina Indian Restaurant. He has been there for about 3 weeks. However, he still is unable to contribute anything to bond due to his length of unemployment prior to obtaining that position. And therefore, again, I am requesting a signature bond, and in the alternative, a very low bond amount, and we are unopposed to the stay away order. Thank you.
Your Honor, prior to your ruling, may I clarify? I believe I misspoke and told the court that the defendant had 3 arrests for theft by shoplifting, but I wanted to confirm that just like pretrial said, they are 3 convictions for shoplifting, theft by shoplifting.
Okay. All right, thank you.
Got convictions?
I'm sorry, pretrial?
I was asking, did he have 3 convictions?
Correct.
Okay. I know I called out 1. I was just making sure.
Thank you.
All right, I'm going to give my ruling. I'm going to order a $1,500 surety bond. I am going to order that there be no drugs, alcohol, or weapons while on bond. That there be a stay away from the sushi restaurant at 299. I think you said MF Sushi.
MF Sushi. Yes, Your Honor.
At 299 North Highland Avenue. So you are not to go back there if you make bond, and while you're on bond, Mr. Eunice. And no drugs, alcohol, or weapons while on bond, and I believe that is all that I need to order at this time. Anything else that I've omitted? Nope.
No, Your Honor.
Okay. All right, that will conclude this matter.
Thank you.
Thank you, Your Honor.
Oh, the case will be reset to January 27th if he doesn't make bond prior to that time.
You can go back. Position number 11, Mr. May.
Good evening, Your Honor.
Then- Okay. You are DeMarcus May.
Yes, Your Honor.
All right, this is case number 22 CR 000-166E. You're being charged with one count of battery family violence. The offense date is December the 29th, 2021. Do you have anything pretrial?
Oh, first arrest is what I have.
Can't see you.
Yeah, that was,
Off.
and that's SOB pretrial recommendation.
All right, your camera's off. I can't see you anymore.
You want me to turn it on and repeat?
No, it's okay. I'll wait to the next case. All right, thank you, pretrial. You said no arrest?
Yes. First arrest.
I mean, first arrest, sorry.
Pretrial was a recommendation.
Okay. All right. Go ahead, Ms. Guidry.
Yes, Your Honor. So on December 29th, officers arrived at the location of 602 Peachtree Hill Circle Northeast, Apartment B in Atlanta due to a physical altercation. They spoke with the victim, Heaven, it's Heabyn, Wilburn, Wilbern, who stated that her and the defendant, who have lived together for the last 4 years, were joking around when it turned serious. The two began to argue, and Ms. Wilburn stated that she leaves the room. The defendant follows her and continues to yell. Ms. Wilburn asked the defendant to leave. He got upset and began to sling her her work computers and her work phone off of the desk. Ms. Wilburn asked the defendant to leave again, and the defendant began to punch her in the face and slam her on the bed. He continued to punch her in the face as she laid on the bed. When she was able to break free, they continued to argue. At that point, the defendant then slammed Ms. Wilburn to the floor, dragged her across the carpet. He proceeded to pick her up by the hair and then slam her into the Christmas tree and on the sofa. Ms. Wilburn sustained a laceration to her nose and burns to her left knee. Your Honor, we're asking for a $6,000 surety bond, a stay away from 602 Peachtree Hill Circle Northeast, Apartment B, or the entire location. No further contact with Ms. Heaven Wilburn, a one-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, the state's concerns here is the extensiveness of what the defendant did. We did talk to the victim, and she is on the Zoom. You will hear that she does not want to press charges and that she may recant what occurred. However, Your Honor, she did tell us that the defendant has been very apologetic and stating that he wants to return so that he can continue to help her with the bills. But as Your Honor is aware, this does occur in domestic issues, and it is the cycle of violence, and it will occur again, Your Honor, given what he did over a simple joke, Your Honor. We are concerned that, like we stated, it will happen again. Even though this is his first arrest, we're concerned that given the extensiveness of what he did, he may sling her again, slam her again, punch her again, Your Honor. And that's why we're requesting such a bond.
All right. Ms. Wilburn, do you wish to address the court?
Yes, ma'am.
Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. Are you in fear of Mr. DeMarcus May?
No, ma'am.
Okay. And that is because?
Well, we've been in a relationship for almost about 6 years. And this is the first time that this has happened. Now I will say that, what happened isn't really excusable. But I think that
Objection.
All right, so
Your
now,
Honor, she is able to speak as to any facts that are relevant to the IALA factors.
go ahead, Ms. Wilburn.
Yeah, so I'm just saying, I do feel like, he has been apologetic about what happened. We've been together for a while and this hasn't, occurred before. So, we kind of have been separated, but we're still talking about, just moving forward pretty much. I'm not in fear of him, but I do think, maybe like anger management class or something could help him. And I did speak to, I forget the lady's name that contacted me earlier, but I advised her that I would be okay with no further violent contact.
Okay. All right, Ms. Gant.
All right, thank you, Your Honor. Today I am requesting a signature bond on Mr. Mr. May's behalf. As we heard, he does not have any prior criminal history whatsoever. We also heard from Ms. Wilson that she is not afraid of him and that they have been in a relationship for the past 6 years without incident. Mr. DeMarcus May disputes these allegations. I would ask the court to not order a stay away in this instance and to order a no violent contact order. Mr. May is 25 years old. He was born in Illinois. However, he has been in the Atlanta area for the past 16 years. He has community ties, including family members here. He completed high school and he is a self-taught music producer. He has been working at EOA Music Studios for the past 2.5 years. And again, I am requesting a signature bond. If Your Honor determines that he is ineligible, then a bond of no more than $500. Thank you.
All right, I'm going to order a $4,000 surety bond. I'm going to order that Mr. May stay away from the location of 602 Peachtree Hill Circle Northeast, which will be the location of the victim. I'm going to order no further violent contact with the victim. I'm going to also order no drugs, alcohol, or weapons while on bond. And I think that will complete my ruling. Anything else I need to take up?
That's all, Your Honor.
Okay.
Thank you, Your Honor.
Your position number 13, Mr. Milner.
Okay, you, Mr. Michael Milner.
Yes, ma'am, Your Honor.
Okay. Let me see who we have representing you. Don't have anyone on camera. Ms. Gant,
Your Honor, I am representing Mr. Milner. I did not hear the position. I apologize.
okay, this is position 13. Yeah. All right. This is case number 22 CR 000170D. And Mr. Milner, you're being charged with 1 count of battery with the offense date of December the 15th, 2021. Pre-trial, do you have anything?
30 total. Last arrest was 2019, probation violation. He's on probation in Rockdale County, possession of a Schedule II controlled substance. 2017, they gave him 5 years probation. Based on the math, he's on probation in Bibb County for ag assault, ag battery. 2002, they gave him a 20-year sentence for that. 10 to serve, 10 probate. What else? 2019 battery family violence, giving false name. That was in DeKalb County. That shows as an arrest. Let's see a disposition for that one. 2014 probation violation, dismissed. Possession of a knife or a firearm during the commission. 2014, not presented to grand jury. 2014 probation violation. 2012 probation violation. 2011 parole violation. 2011 FTA for simple battery and obstruction.
Okay. Right. Did I cut you off? Were you saying something else?
I'm done.
Okay. All right, Ms. Guidry.
Yes, Your Honor. So here, officers arrived at Grady Hospital due to an incident that occurred in Centennial Park. When they arrived, they spoke with Miss Renita, R-E-N-I-T-A, Pittman, who stated that the defendant came to visit her. She met with him in the parking lot near the park with 2 beers for them to drink. As they drank, the defendant attempted to physically rub her sexually. Miss Pittman declined such touching, and the defendant got upset. He punched her in the head with his fist, causing a visible knot to her forehead. Ms. Pittman, in turn, scratched the defendant in the face during the altercation. She ended up face down somehow in between the seats and could barely breathe. She advised the defendant that she couldn't breathe, and he told her, "Die, be die." And then he punched her in the jaw. The defendant then got out of the car, jumped into the driver's seat, and continued to curse Ms. Pittman, and then dropped her off at Grady Hospital where he left her. In addition to the knot on her forehead, she also received a laceration to her bottom lip and a swollen jaw. Your Honor, we're asking for a $5,000 cash bond, no further contact with Ms. Renita Pittman, a 1-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, the reason for our concerns is the defendant's criminal history. He had an arrest for battery family violence in 2019. It seems as if it was dismissed. He also has an aggravated assault charge and an aggravated battery from 2002, which he was convicted of, terroristic threats and battery, one from 2000 and one from 1995, robbery by intimidation of 1991. We're also concerned of intimidation of the witness. We did speak with the victim, who is present on the Zoom. She stated that she is in fear for her life, Your Honor. The defendant came to her job last Tuesday and started cursing her out in front of everyone just because she hasn't returned his calls. He also has left voice messages threatening her. So, Your Honor, we're very concerned for her safety and that he will reoffend given his criminal history and just by him calling her last week. So that's why we're asking for such a bond.
All right, Ms. Gant.
Thank you, Your Honor. Mr. Michael Milner denies the allegations. He denies being the primary aggressor. He states, in fact, that he was scratched first by Ms. Renita Pittman. He states that he told the defendant, the complaining witness, that he was getting married and that he no longer wanted to continue seeing her, and she became very irate and attacked him. He denies dropping her off at any hospital for treatment. In fact, he states that he dropped her off at home, which is near the hospital. In light of his denial and clearly a question about the primary aggressor in this case, I am requesting a signature bond. And if Your Honor determines that he is not entitled, then a bond of no more than $200. We are unopposed to the no further contact order. And while I acknowledge my client's history, we did not hear about any convictions for violence since 2002. I believe the last was 2002 for aggravated assault. Although he has had contact with the criminal justice system, his last FTA was over 10 years ago. Therefore, I do believe that he isn't a flight risk. Furthermore, he has ties to the community. He is 49 years old. He's born and raised in Atlanta. He completed the 10th grade. However, he went on to trade school to complete studies in carpentry. He is self-employed and has been so for the past 3 years at a strong arm handyman improvement services company. And for these reasons, Your Honor, I am requesting a signature bond. If Your Honor determines that he's ineligible, then a bond of no more than $200. Thank you.
All right, I'm going to,
Judge, the victim is on the line.
oh, I'm sorry, I forgot. Yes, Ms. Pittman?
And Your Honor,
Yes, Ms.
I
Gant.
would request that she limit her testimony to her wishes for contact with Mr. Milner.
Again, Your Honor, she is able to speak to anything in regards to the IALA factors, as this is a bond hearing.
All right, Ms. Pittman, do you wish to address the court?
Yes, ma'am.
Can you raise your right hand? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, put your hand down and go ahead and tell me, are you afraid of Mr. Milner or in fear of him?
Yes, I am.
Okay.
And I say that because after he assaulted me in the back of his car.
Objection, Your Honor.
Your Honor, again, anything she speaks to deals with the IALA factors, which is the intimidation of the witness. So she is able to speak as to that.
Okay. And if you're talking only about this incident regarding.
Only about this incident.
Okay. All right, go forward.
I call myself handling the situation by not answering any phone calls or texts, which made him leave voicemail saying if I don't answer his phone call or text, he's going to show up at my house or job. He came to my job and completely cussed me out last week.
Your Honor.
My supervisor had to ask
I
him to
object,
leave.
Your Honor.
Okay. All right.
We're renewing our same stance, Your Honor.
I have one more. If y'all can pull the tape from Grady emergency room on that night, you will see his car dropping me off.
Okay. So you're stating that he did drop you off at Grady?
Yes, ma'am.
Okay. All right. And you all don't live together, do you?
No, ma'am.
Okay. All right. Do you want to ask any questions, Ms. Guidry?
No questions, Your Honor.
Ms. Gant, do you want to ask any questions?
No questions, Your Honor.
Okay. All right, hold on, Ms. Pittman. Go ahead and mute yourself and hold on a second for my ruling, okay?
May I say something?
Mr. Milner, I advise you to remain silent. Any statements that you make will be used against you, sir. The judge hasn't ruled yet. Please allow the judge to rule.
Okay, I'm asking the judge, can I say something in my defense?
You have an attorney for that, Mr. Milner.
My attorney's wishes, I'm asking you, is that my right?
Well, you have an attorney, and if you do state anything about the facts or allegations of your case, the state is listening and it can and will be used against you. So you need to be careful. You need to be very careful and listen to your attorney. Let me allow your attorney to speak first, okay? Because she may touch on some things that will clear up and you may not need to ask a question. So let's let your attorney go first.
As a man and as a defendant, can I speak?
Your Honor.
After your attorney goes first, let your attorney speak first, okay? All right.
All right. Mr. Milner, I advise you not to make any statements. And if I may request that courtroom to mute that microphone, please.
Well, it's my case, it's my life. Can I go against that, Your Honor?
I do not want you to compromise your case, sir.
I hear what you're saying, and I'm asking the judge, can I speak in my defense against your ruling?
Against your attorney's advice, possibly, but I'm not going to allow it just yet. If I do, let me hear from Ms. Gant first. We're trying to protect your constitutional rights. So hold on a second. Let me hear from her first, okay?
Yes, ma'am.
Okay. Go ahead, Ms. Gant.
Your Honor, I have nothing further to add at this time.
All right. And how old is Mr. Milner?
Mr. Milner is 49 years old.
Is he working?
Did I not present my case? I'm happy to provide information, but did I present my case?
I don't think so. Did you?
Yes, I will do. I'm happy to do it again.
Well, and I wrote down some notes, and it's possibly that I didn't, but I heard 49 years old, dropped off, and I wrote some things. If you don't mind, could you please refresh me?
Yes, Your Honor, thank you.
Okay.
Mr. Milner is 49 years old. He is a lifelong Atlanta resident. He has family ties here. He has family in this area. He completed the 10th grade. He also went on to complete a trade in carpentry. He is self-employed and has been so at Strong Arm Handyman Services for the past 3 years. And as I emphasized earlier, despite my client's extensive history, his last conviction for violence has been back in 2002, which is over 20 years ago. Further, despite having further instances with the court, he last failed to appear over 10 years ago. Therefore, I do not believe that he is a flight risk. We are unopposed to a no further contact and a stay away order, which will definitely take care of any concerns whatsoever regarding intimidating this witness. Again, I object to any testimony regarding any occurrences that happened after or before this event, and just ask that Your Honor focus on what's before the court now. And I will again reiterate that my client denies the allegations. He denies being the primary aggressor. He states that he was attacked first, that Ms. Pittman became upset because he informed her that he was getting married and would no longer be able to see him. He denies dropping her off at Grady Hospital. He states that her home is near Grady Hospital, and that is where he dropped her off. And for these reasons, Your Honor, a signature bond is what I'm requesting. And if Your Honor determines that he is ineligible, then a bond of no more than $200. That is all that he has to contribute toward bond. Thank you.
All right, Ms. Guidry, you had stated your recommendation was a cash bond.
Yes, Your Honor, given that he just contacted her last week. He went to her job and he's been leaving her voice messages where he's been threatening her. So we're very concerned. And you've also heard Ms. Pittman's concerns as well, Your Honor. So we're very concerned that when he gets out, he may commit another act, even given his criminal history.
Okay. All right, I'm going to make my ruling to order a $5,000 cash bond for the battery charge.
$5,000 cash.
I'm sorry, Mr. Milner. What did you say?
That's why I was begging you to speak, ma'am, before your ruling. If you just grant me that, I'm not trying to interfere with your ruling. Me and this woman been friends 28 years.
Mr. Milner.
Okay, you don't gave me that. I'm a grown man. Can I speak for myself now? I'm asking the judge, can I speak? You don't gave me that warning. I want to go against that warning. You don't have to say that no more. Now, ma'am, I all due respect, Your Honor. All I beg you to do is speak. Some is true, some is false. I've been dealing with this woman for 28. I'm not important me doing that to her. I didn't do that to her. I heard her. I've been dealing with her 28 years. We ain't never been through nothing like this. All she know, all she had to do was tell me, I don't want to see you no more, and I would never bother her no more. All this stuff is fabricated. It's a lie. My birthday is in 2 days. I ain't did nothing but change my life. Yeah, I went down, I did the prison, but I changed my life when I came home. I started my own business. It ain't no fake business. It ain't no business that you tell the court, and then when you look it up, the Department of Treasury, it don't exist. It's a real business. I have my own equipment and everything. I have made a 360-degree turnaround in my life. And that woman been knowing me long enough to know if she say, well, Michael, I don't want to see you no more this year, I will leave her alone. I don't know what brought this on. We have had disagreements before. It ain't never led to this, Your Honor. She know I respect her as a woman and love her as a person enough to back up. I know her children. She knows she ain't got to do this. She knows she says, well, Michael, it's time for me and you to leave each other alone and not bother her. She 28 years on and off. She know I'm gonna respect that. It's blown out of proportion, Your Honor. That's all I'm saying. I have made a 300. Look at my record and look at me now. I have made I ain't never had a banking account with a $200 or $300 in it. I got a banking account with a few dollars in it. Would have more if it weren't for the pandemic. I got a legitimate business. You can ask her that. I have came so far for something to be blown out of control. That's all I'm saying. Miss Pittman, no, we have been through some things, but never to this magnitude. I would never go that extreme to harm you. I'm not perfect, and I'm not. And you know that. All the things that we have been through together as friends, not lovers, friends, you have been there for me when we wasn't together. I have been there for you when we wasn't together. When nobody was there for you, I was. It don't cost for this. You know, you could have just told me, Michael, it's time to bag up. It don't take this neither, and you know that. And you know this, sweetheart. 28 years. You know it don't take this for me. We don't stop seeing each other. You don't call it quits. I don't call it quits. We don't stop for a year or two. Then you'll call.
Your Honor, I'm sorry, I'm going to object. If if I may, Your Honor, if the defendant is going to speak, I would appreciate it if he not speak directly to our victim. He has something to say, he can say that to the court, but he needs to stop addressing his comments to the victim.
Yes, ma'am. And I apologize. But like I was saying, y'all, I don't came too far.
Okay.
And
All right.
It don't take this. We don't stop seeing each other before, and it didn't never take no violence or no police. All right, Michael, we don't need to see each other, and that was it.
Okay. Well, that is all that I'm going to hear at this time, Mr. Milner.
I can't pay that kind of bond, man. I can't. And I don't came a long way, y'all. And I ain't been in no trouble in years.
All right. Anything else from the state, Ms. Gidring, before I may revise my ruling a little bit?
Your Honor, just given the facts again, it doesn't show that he's changed at all. To say that someone couldn't breathe and he told her what he told her,
that's just an allegation.
Die, Your Honor, he has not changed, Your Honor.
Mr. Milner, I'm going to ask you to please refrain from speaking. Do not talk anymore. I've given you an opportunity. Don't want to. Okay. All right.
I came too far, man.
All right. What I'm going to do is I'm going to order a $10,000 surety bond as opposed to the cash bond, but it'll be a $10,000 surety bond. I'm going to order a stay away from the location that Ms. Pittman resides in. I did not hear that address, but I'm going to order stay away from her home location and her work location, and we will get those addresses. I'm going to also order no further contact with Ms. Pittman. I'm going to order no drugs, alcohol, or weapons while on bond. And I mean that, Mr. Milner, if you make bond,
yes, ma'am,
because you have a $10,000 surety bond, if you make bond, then you are not to contact her by any means. You're not to use social media, phone calls, or any type of means, any third parties, any other persons to contact her. You're to stay away from her. And I believe the bond states, is it 100 yards or 200 yards?
You got my word, John.
You are not to go around her or anybody near or around her at all. If you make bond, if you don't make bond, your case will be reheard on January the 27th.
Okay, can you explain that a surety bond to me? I'm not familiar with that.
Your attorney will explain that to you, to use a bonding company.
Someone please put in the chat to Katrina Lewis the address for the stay away.
And Your Honor, I have asked that Ms. Pittman just put in the chat her address, her work and home address, just directed to myself or Ms. Lewis via direct messaging. I ask that she do not send it to everyone in the message. So that way we have that information to put in the bond order.
Ms. Pittman, do you know how to do that? Ms. Pittman, unmute yourself for a second.
Yes,
do you know how to use the chat feature to put your addresses in there for the stay away provision? Okay, you do.
And who will I need to address it to?
Do you see Miss Lewis?
Miss Lewis? Yes, ma'am.
Yes, just click on her to pull down and just select Miss Lewis so that it only goes to her. And if you can type both of those addresses in there, we will put that in the bond order as to where Mr. Milner should not go. If he goes to either of those places, he will be immediately arrested. If he contacts you by any means, you are to call the police and he will be immediately arrested. And Miss Lewis, let me know when you have that. I think she's still typing.
I received it.
Okay.
Is there a name for your job? Is there a title or it's just a location? Ms. Pittman.
You're muted.
Okay, I see it now. She put it in.
Okay, she put it in there. Good.
Thank you.
All right. All right. Is there anything else that I need to address from either side or from the victim as far as any locations that you want to include in the stay away order?
Nothing from the defense, Your Honor.
Just my home and my job.
Nothing
That's the
further,
only
Your Honor.
place I be.
Those only two. Okay. All right, Ms. Pittman, good luck to you.
Your Honor, we done here
Thank
in
you.
courtroom 2. May we be excused?
Yes, you may.
Thank you, Your Honor.
Well, yeah.
Next, we have Your Honor from the South Annex, position number 6, Ms. Carolington. Garlington.
Does anyone know on position 4, is that still Grady or medical?
Yes,
Yeah.
he's still loan out Grady.
Still loan at Grady, okay.
Also, I've been told that position, I believe 9 is in quarantine. That's gonna be reset for tomorrow. Mr.
James.
Brian James,
Yes,
okay. All right, go ahead, South Annex.
Position number 6, Ms. Garlington.
Okay. Jasmine Nicole Garlington. All right, your case number is 22 CR 000171B. And you're charged with 1 count of driving hit and run. You're charged with a 2nd count of duty of driver to stop at or return to the scene of an accident, and a 3rd count of failure to obey a stop sign. And the offense date is December the 2nd, 2021. Pre-trial, do you have anything?
I got 2nd arrest. Last was the DUI from June. What say you, state?
All right, Ms. Arnold.
Yes, Your Honor. So the defendant currently has a bond, a split bond, a $1,000 surety bond for the driving hit and run, and $0 unsecured judicial release for count 2 for the failure to obey the stop sign. We are just asking that the bond remain in place at the $1,000 surety, and that there be no drugs, alcohol, or weapons, and no driving. Your Honor, this incident happened on December 2nd, 2021, at the location of 16th Street Northwest and McCaslin Street Northwest in Atlanta. McCaslin spelled MECASLIN. Mr. DeKeven Perry, DeKeven, I'm sorry if I'm mispronouncing that, is spelled DAKEEVEN, Perry, informed officers that he was traveling eastbound on 16th Street Northwest when he was struck by another vehicle that was being driven by the defendant. After the defendant failed to stop at a stop sign at the intersection of McCaslin Street and 16th Street. Mr. Perry was able to provide officers with the defendant's tag information, and officers found the defendant from a tip using that same tag information, where the tip was that the defendant was having her car repainted, and the front suspension was being worked on. When officers contacted the defendant, she did admit that she was involved in the crash and that she did in fact leave the scene without giving her information. Your Honor, we did speak with the victim in this case, Mr. Perry. And he did mention that he did not suffer any injuries from the accident. However, he stated that the defendant shifted his fender on his vehicle, and that the passenger side door will not open. The grill of his car is damaged, the hood is lifted up, and now the car shakes while it drives. Victim stated that he has an estimated over $1,000 to fix all of those different things that are going on with his car, the damage to his car. And for those reasons, Your Honor, although the defendant does not have a lengthy history, we do have the one DUI conviction out of Colorado. We are asking, Your Honor, that based on the facts of this case, that the bond remain at the $1,000 surety. And again, that there be no drugs, alcohol, or weapons, and no driving.
Okay, can I say something?
No, don't say anything at this time, ma'am.
And so let me be clear, there is right now an existing $1,000 surety bond on the hit and run. And then what did you say on the second charge? It was no bond?
It says $0, unsecured judicial release.
Okay. All right, I was just making sure. All right, go ahead, Mr. Coleman.
Yeah, I would be requesting a signature bond from Ms. Garland. Looks like this is only her second arrest. She is 28 years of age. She attended some college. She is a military veteran, also working for DoorDash. Looking at the paperwork I received from the jail, it looks like she was arrested on January 6th. Today is now January 12th. I don't know why she is just now being brought before the court for a bond, so this may be a Riverside issue. So again, based on the foregoing, I will be requesting a signature bond from Ms. Garland.
All right. All right, I'm going to grant a signature bond through the jail. I'm going, and oh, I'm sorry, in the amount of $2,000 for the hit and run, and then $500 on the failure to obey the stop sign. So it'll be a total of $2,500. No drugs, alcohol, or weapons while on bond, Ms. Garlington.
Yes, ma'am.
And also no driving except for work, medical appointments, and visit your attorney, but you'll have to get that driving privileges or certificate from DDS. Otherwise, you cannot drive since your license are probably already suspended anyway. And of course, no drugs, alcohol, or weapons while you're out on bond. And your case will be further noticed by the division judge. Anything else that I've left out?
No, thank you.
No, Your Honor.
Okay.
Next, we have position number 12, Ms. Mendez.
All right, are you Sandra Mendez?
Yes, ma'am, I am.
All right, this is case number 22 CR 0000167Y. You're being charged with one count of battery family violence with an offense date of January the 11th, 2022. Pretrial?
28 total. Last arrest was 2018, possession of marijuana. There's one arrest out of South Carolina, 16 out of California. 2017 shoplifting, misdemeanor possession of marijuana, that was out of Clayton County. 2015 obstruction conviction. 2013 failure to appear. for one of those public order crimes. 2009 probation violation, simple battery, disorderly conduct. 2009 felony theft by taking, financial transaction card theft conviction. She pled NOLO in 09 to obstruction, disorderly conduct, simple battery. 08 failed to appear, 07 shoplifting conviction. You want the California history? The last arrest there was in 2006. A burglary second degree arrest. I'll leave it at that.
No, Ms. Guidry, I'm sorry.
Yes, Your Honor. So in this case, yesterday, officers arrived at the Sheraton Hotel located at 165 Cortland in Atlanta due to a call about a dispute in the hallway on the 8th floor while a child was left alone in a room. Upon arriving, they could hear a loud dispute coming from room 819. They repeatedly knocked and beat at the door and no one would let them in. They could hear a female voice screaming hysterical and a male voice asking if he could just leave the room. As they continued to knock and announce who they were, someone tried to get out of the room, but someone else was holding the door shut. When officers were finally able to get in, they spoke with the victim, Julius Dixon, common spelling, who stated that he and the defendant had gotten into a fight where the defendant hit him in the face. Officers did observe that Mr. Dixon had a bloody lip. They continued to speak with him, and he continued to just state that he wanted to leave and that he did not want to press charges against the defendant. Officers then spoke with the defendant, who stated that Mr. Dixon had choked her in the elevator, but then she stated that she had in fact bit Mr. Dixon's lip, but only because he was choking her. Officers asked the hotel if they had video footage of this event occurring, and the security stated that they did not. The defendant continued to state that Mr. Dixon in some way harmed her, but officers ruled her as the violent party. Your Honor, we're asking for a $2,500 surety bond, no further contact with Julius Dixon, 1-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, the state's concerns here are intimidation of the witness, given that there has not been a 24-hour cool-off period. We're also concerned, given the fact that the victim was trying to leave the room and she would not allow him to, holding the room door closed, and then tried to insinuate that he in some way committed a crime against her, when in fact it was her who committed the crime against him. Her criminal history, she has simple battery from 2019, 2 counts conviction, also a 2003 conviction battery out of California. And she's also a flight risk, given that she had a failure to appear in 2007 and 2013. And Your Honor, that's the reason for the state's recommendation.
Okay. I think I see the victim, Mr. Julius Dixon, on the Zoom screen.
Yes, Your Honor, I believe so. Mr. Julius Dixon, is that you? That says Julius phone?
Yes, ma'am. This is me.
Okay, do you wish to address the court?
Yes, I would, Your Honor.
All right, can you raise your right hand? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
Okay, put your hand down and state to me, are you in fear of Miss Sandra Mendez?
No, Your Honor, not at all.
And what is your relation to the defendant?
She's my child's mother.
Okay. Do you all reside together?
We have separate residence. She but we do coincide commonly. I'll go to her place or she'll come to my place. We share a child we take care of together.
How old is the child?
She's 2.
2 years old, okay. All right, and is there anything else that you want the court to know about this particular incident on January the 11th?
Yes, ma'am. I am no shape, form, or fashion want to, pursue this. She didn't do anything to me. I love her. We had a disagreement, and I was just trying to get out of there, and she just wanted to talk to me. And I love her. I didn't call the police. No, we may have, got a little, escalated the volume, may have gotten a little loud. We were having a great day, a wonderful night. We had just left dinner. Everything's is fine. I have no problems. She have no problems. We have no problems at all. Just a dispute. And we just want to get her home to help with the baby, and so we could just continue on with our life.
Okay. All right, Ms. Gant.
All right,
I'm
thank
sorry,
you,
Ms.
Honor.
Guidry. I'm sorry, excuse me, Ms. Guidry, do you have any questions of the victim?
No questions, Your Honor.
Okay, go ahead, Ms. Gant. I'm sorry.
All right, thank you, Your Honor. Ms. Mendez is 34 years old. She was born in California, but she has been in the Atlanta area for 11 years. She has community ties here. In addition to the 2-year-old daughter that she shares with Mr. Dixon, she also is the proud mother of a 19-year-old daughter and also 2 additional daughters, ages 11 and 4. Ms. Mendez completed the 12th grade. She had been working in healthcare as a home health aide up until Thanksgiving. At that time, she encountered some health problems and had been unable to really get back to employment until December 24th. Therefore, she has a very limited ability to pay any bond. At this time, I am opposed to a stay away. At this time, we heard from Mr. Dixon. He is not afraid of her. Ms. Mendez disputes the allegations. Furthermore, Mr. Dixon, I spoke with him, and Ms. Mendez confirmed that there is a business that Mr. Dixon owns. It is JD Energy Solutions, and that she is quite helpful to him in keeping that business afloat. And of course, both rely on that to provide for the care of their 2-year-old daughter. We are unopposed to the 1-day anger awareness program. And we do not believe, just based on Mr. Dixon's testimony, that there's any risk of intimidating the witness. And for these reasons, Your Honor, I am requesting a signature bond. If Your Honor is not so inclined, then a bond of no more than $1,000. Thank you.
All right. And did I hear you state, Ms. Gant, or I don't know if Ms. Guidry knows, that the defendant works in the victim's business, or they have a business together?
I offered that information, Your Honor. The business is owned by Mr. Dixon, and Ms. Mendez helps him to keep the business afloat.
Pre-trial, does she qualify?
No, because of the open case. I got an open 21 CR 003-628Y. State, did you mention that? I wouldn't.
No,
I didn't hear about an open case.
It may
Your
be
Honor.
incorrect. Let me check it out. I'll check it out.
Okay.
And while he's checking, I did have a chance to talk to Ms. Mendez about that, and her belief is that that case was dismissed. And that
Oh, it shows open in Judge Eady's court. Yeah, it was filed on July 21st, 2021.
What's the charge?
I don't know. Hold on, it's spinning.
It's simple battery, Your Honor.
Yeah. Let me look at the accusation. Hold on. Striking Anaya White.
Okay.
Yeah, it shows open.
Okay, that's not the child. In this case is only 2, so that's a different child, right?
Your Honor, Anaya is her 19-year-old daughter. Anaya currently has she's currently keeping her 2-year-old child. Now, there have been no instances, between the two. And Ms. Mendez states that they both completed family counseling, and her belief is that the case was dismissed and that she had fulfilled every obligation.
Okay. All right, I'm going to order a $2,000 surety bond. And I'm going to order that, I guess with the address that I had, which was the Sheraton Hotel on Cortland, I assume that's not the residence address, correct?
That's correct, Your Honor. If Mr. Julius could give us the address within the chat, that would be great.
Well, I was not going to order a stay away in case she does make bond, since it appears that I don't know if she has anywhere else to go, but if there are no objections to that, I won't order a stay away from the marital residence. Just no further violent contact with the victim, Mr. Julius Dixon.
Yes, ma'am.
Okay. And so you understand that, Ms. Mendez, you're to have no further violent contact. I won't order you to stay away from the home at this time. And hopefully there won't be any more incidents, no drugs, alcohol, or weapons while on bond. And if you make bond before the next court date, which is January 27th, then you won't have to come back on that date because you'll already be out on bond. But I'm going to go ahead and render an order of a $2,000 surety bond. Is there anything else that I need to take up?
Nothing further, Your Honor.
In the defense.
Okay. All right. That will conclude this matter.
Thank you, Your Honor.
Mm-hmm.
Thank you, and that's it from the South Annex. May we be excused?
Yes, you may.
Thank you. Have a good.
All right. Have a good day. All right. And I
What happened with number 10?
think that's the one that's still, oh, I don't know. Erica Jones. Does anybody have any? I think I've let.
Your Honor, she was a medical reset from yesterday. And actually, I believe the day before. This may either be her first reset or her second reset.
Okay, so we'll just put that on medical still.
And as I understand it, a loan out to Grady, which is medical reset.
Mm-hmm. Okay.
That is correct.
Yep, I think we've got a couple on here like that. Whenever you're ready, Ms. Lewis, we will defer to you.
Okay. Okay, here we go. All good bonds are reset for the SAP for January the 27th. Position number 1 is a 3,500 SOB through the jail. Position number 2 is reset further notice. Position number 2 is a $4,000 SOB through the jail, reset further notice. Position number 3 is a $2,000 good bond, reset for SAP. Position number 4 is reset to the next SEA counter for medical reason. That'll be tomorrow, January 13th. Position number 5 is a 1,000 SOB through the jail. Case is reset further notice. Position number 6 is a total of a 2,500 SOB through the jail. Case is reset further notice. Position number 7 is a $5,000 total good bond set for SAP, January 27th. Position number 8 is a $5,000 total good bond reset for SAP, January 27th. Position number 9 is reset for the SEA counter tomorrow for January the 13th due to quarantine. Position number 10, same announcement, reset SEA for tomorrow due to medical reason. Position number 11 is a $4,000 $4,000 good bond. Reset for SAP January 27th. Position 12 is a $2,000 good bond. Reset for SAP January 27th. Position number 13 is a $10,000 good bond. Reset for SAP January 27th. Position number 14 is a $2,500 SOB through the jail. The case is reset for the notice. Position number 15 is a $1,500 good bond. Reset for SAP January 27th. Any questions?
Nope, I think we've got them. Anyone else? All right, we will see you all next time. Thank you, everyone. Good afternoon.
Thank you, Your Honor.
All right, thank you.
Bye.
All right, bye-bye.
Bye-bye, Your Honor.